case bonded.
Oh, thank you.
Your Honor, Mr. Nathan Worley.
Okay.
Was I really muted that whole time? Oh my gosh. Okay, Natty Boh. If you don't know what Natty Boh is, it's a beer. It's National Bohemian. It's a real cheap, terrible beer, but it's always around. People always have it. It's a beer. All right. Um, I can't remember what else I said in the last few minutes while I was muted, but that's okay. We're in court, so everybody be quiet. Hi, Priz. Oh, I said hello to hi, Elizabeth. I said hi, CRD. I said hi to everybody, but I was muted. So if I didn't say hi to you, I did. Don't worry. Here we go.
So this will be the matter of Nathan Worley, 24 CR 5008. We have Mr. Doherty for the people, Ms. Goldstein for defendant. Ms. Goldstein, were you able to meet with your client in this matter?
Judge, I did speak with Mr. Worley yesterday. We would waive Rule 5 advisement. Thank you.
This
Okay,
is a
thank
slow
you. Ms.
burn.
Doherty, your comments
Comes
on
at the
bail and
end.
bond, please.
Your Honor, I would note in this case, the pretrial services report places Mr. Worley at a category 4. His failure to appear history is significant, 52 in the last 5 years. A chunk of those are felony cases. Really, without going too much more into it, Your Honor, we would be objecting to a PR bond. I lead up to the court, whether cash surety bond or whatever level is appropriate. Judge Europe typically doesn't do cash surety bonds, does cash or PR. That's his policy, but I'll leave it up to the court of what level is appropriate on this. I would ask for a standard protection order otherwise. Thank you.
Okay. Thank you, Ms. Doherty. Ms. Goldstein, your comments on bail and bond, please.
Thank you, Judge. Judge, my client has been staying with a friend in Delta. I understand the prosecutor's concerns regarding my client's ability to appear for court. Certainly, I think my client has been struggling with that, although he tells me that a majority of his FTAs occurred because of inadvertence on his part. So I would ask for a PR bond for this property crime. Alternatively, I'd ask the court or suggest to the court that $150 cash only bond. Thank you.
Okay. Thank you, Ms. Goldstein. Mr. Worley, having heard the arguments of counsel, having read the documentation that accompanied your arrest, noting that you are a CPAT level 4, noting the extraordinary numbers of failures to appear, the court does not find that a personal recognizance bond is appropriate. Incorporating the local rules and practices in a matter like this, bond will be set as a $5,000 cash only bond. In addition to bond set at that amount, you are to remain law-abiding while on bail and bond. You're not to leave the state of Colorado without court permission. If you do need to leave the state, I want you to get permission from the court at least 2 weeks in advance. You will sign a waiver of extradition. Waiver of extradition is a document that says if you leave Colorado and you're arrested in another state, it won't be up to a judge in that state to determine whether you'll be returned to Colorado. And you are not to drive without a valid driver's license. In addition to bond set at that amount, with those conditions, the court will also issue a protection order. Excuse me. Before I go any further, should you be released, you are to have enhanced pretrial supervision. That is enhanced pretrial supervision through Delta County Pretrial Services. In addition to bond set at that amount, and with those conditions, the court will also issue a protection order. This protection order is a condition of bail and bond. Should you violate it, you will find yourself subject to additional criminal charges. Terms are that you not harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts you're charged with committing. You're to stay away from the victim in any location where the victim is or is likely to be found by 50 yards. You're not to contact the victim either directly or indirectly. and you are not to possess, purchase, or control firearms, ammunition, or other deadly weapons. Mr. Worley, are you a veteran or an active duty member of the United States military?
No.
Do you wish to be represented by the public defender in this matter?
Yes.
Yep. If you're able to post bond within 7 days of leaving the detention center, if not sooner, I want you to submit an application to the court requesting representation by the public defender. So long as you remain incarcerated, a public defender will be assigned to your case. Your next court date is April 15, 2024, 2 p.m., courtroom 1. Again, that's April 15, 2024, 2 p.m., courtroom 1.
But
So,
Judge,
Mr.
wait.
Worley, through counsel, we waive further reading and advisement. We set bail and bond. We issued a protection order and talked about its terms. We discussed representation by counsel, and I set your next court date. Regarding bail and bond, do you have any questions or concerns for me?
Yeah, what about the cops that stole personal information being related to this case? I want to press charges against all of them involved.
Of course he does.
Mr. Worley, that's something that you can take up with your attorney, but we will not be going over that today. Ms. Goldstein, anything additional from you?
Mr. Worley, I would just tell you that because it appears unlikely you will be posting bond, the public defender will be with you tomorrow in court, and certainly you can share your concerns with your public defender about wanting to press charges. I wish you the best of
They
luck,
would love
sir.
that.
Mr. Doherty, anything additional from you?
No, Your Honor. Thank you.
All right. Good luck to you, Mr. Worley.
I do feel so bad for these attorneys sometimes. They just have to deal with it, and they don't have a choice, and they have to be nice. Oh my goodness.
There we go. Good morning. Please state your name for the record.
Hi, my name is Marie White-Skunk.
Good morning. I am Magistrate McDonald. This is case number 24 M5015.
We'll waive any further advisement.
Thank you, Mr. Moran. And Mr. Colquitt, people's position on bond.
Judge, normally this would be just a one-off case, other than the fact that since 2023, Mr. White Skunk has picked up.
It's Miss White Skunk, not Miss White Skunk. Yeah.
I'm sorry?
It's Miss White Skunk, not Miss.
Oh, excuse me, Miss White Skunk has picked up 6 new cases since 2023, multiple assaults, assault threes, multiple victims, extensive criminal history going on just in the recent past, has 2 now open cases. This case and another case just received probation back at the end of January. And while on probation and getting the benefit of the dismissal of multiple assault threes, gets another VPO alcohol and assault 3. So clearly what we have is somebody who's not coachable, not willing to follow directions, and has a severe alcohol problem. Based on that, for the safety of the community and for the safety of Miss White Skunk, we would ask for $2,500 cash or surety. We would ask for pretrial services of electronic full-time monitoring, because obviously alcohol is an issue, and when alcohol gets involved, then violence breaks out and we end up here.
Mr. Moran.
Your Honor, Ms. White Skunk is not safe in the jail. She's housed in the male housing units. So I would respectfully disagree with the assessment that there's any way that we're enhancing her safety at the jail. She's also experienced really significant prejudice and unfortunately has on occasion had to defend herself, like the instance that has landed her in the jail most recently today. She does have a job working in the Human Resources Department at the casino on the Mountain Ute Tribe Reservation. What she's described to me, I think, is going to make for a very strong claim of self-defense. There's apparently cell phone footage of the individual who's the complaining witness here attacking her and other people in the park. There was a concerned citizen who contacted law enforcement, and unfortunately they caught the tail end of it and didn't see that what happened was occasioned by the complaining witness having what Ms. White Skunk believes may have been a mental breakdown. The behavior was inexplicable. She was endangered. She was with her mom. She was really worried about her mom being attacked, her elderly mother, who is legally blind. Ms. White Skunk lives with her mom. Rather, her mom lives with her and relies on Ms. White Skunk for all of her daily needs, housing, food, all of what is attendant to not being able to see. She has called law enforcement in the past on this individual who she is going to make a claim of self-defense for. She denies consuming alcohol. I know that that's inconsistent with what we're seeing in the affidavit, but I don't see that her blood alcohol content was measured, so that I don't see any proof that she was consuming alcohol. And so I'm taking her at her word. She also reports to me having graduated high school, being a lifelong resident of the area, except for when she was in college in Denver at the community college studying business management. So on that basis, we're requesting that Your Honor allow her a personal recognizance bond.
Okay, this is curiously, Mr. Moran, my notes indicate what was her BAC. So I was in the same boat in terms of reviewing that affidavit. But I'm not necessarily drawing the same conclusions as you. Nonetheless, I see that there's a challenge here in determining what's an appropriate path. I am concerned with the suggestion that there are safety concerns while in the jail. Very concerned. I am going to order a $2,500 PR bond. I'm going to authorize pretrial services, no alcohol, no drugs, no illegal drugs, no recreational marijuana, monitored sobrieties directed by pretrial services. You must remain law-abiding at all times. Because you're alleged to have violated a Title 18 charge, you are subject to a mandatory protection order pursuant to CRS 18-1-1001, which will remain in place until final disposition of your case. Pursuant to this protection order, you may not harass, molest, intimidate, retaliate against, tamper with any witness to or victims of the acts charged. I am going to order a no contact order with the alleged victim, Troy Vicente. That will be a 25-yard distance restriction. And your next court date
I literally have a deputy here that did my BA right here. My breathalyzer test. Deputy Joel did my breathalyzer test for the first time, and I blew zeros. That's the first time I came into custody. There isn't anything that says that I blew numbers. And I was asked by the officer if he apprehended me to be into booking, if I was gonna blow numbers. I blew zeros the first time. There wasn't any record of it saying that I honestly blew anything, that I was under the influence of nothing. And like I said, I told my public defender here that I have Richard Sims mainly as a private attorney because I have an interest of conflict with the public defender's office in Durango. So I'm always assigned to Richard Sims. I'm not assigned to the public defender typically.
Literally.
But in the situation, I told him, yeah, I do have record of this individual 4 hours ago prior harassing the whole community, making threats to everybody. Someone called it in. I don't know the individual. I don't know anything about them really. My mom is standing with me and I recorded the whole entire thing.
Ms. White Skunk?
I know, but I showed the officer this
I suggest that you not make any further.
I know. I'm just saying though, I honestly, I had asked the officer just because I want to be a law-abiding citizen.
Ms. White Skunk,
I get it. I know.
A bad idea.
I do what, but I just
discussing the facts of the case. Ms. White Skunk, if you could please.
I know, but I'm not even being a danger to no one though. I'm not. I'm really serious. I literally asked the cop if someone put hands on me, do I have a right to self-defend myself?
Ms. White.
I'm just saying though, I literally not under the influence of nothing. I wasn't high. I wasn't intoxicated, Your Honor. I'm telling you the truth. And
Ms. White Skunk,
right next to me did my BA for the first time. Like, I literally blew zeros. I didn't blow any numbers whatsoever.
Ms. Weiskunk, my order stands, and I've authorized a PR bond. I think that under the circumstances, I'm trying to both protect the community and make sure that you have the opportunity to be released.
The
So,
officer, I didn't even know the officer would let go that person.
Hey,
Your Honor.
Ms. Whiteskunk, don't talk over me.
I'm
It's
sorry, Your Honor.
not,
I'm so
not all
sorry.
that pleasant.
I
I'm
forgive
really
you. I'm so
patient,
Yeah, I'm
and you need
sorry.
to stop. So
I'm so
please,
sorry.
your next hearing date is April 17 of 2024 at 9 a.m. in courtroom 1. Is there anything further, Mr. Colquitt?
No, Judge.
Is there anything further, Mr. Moran?
Your Honor, what was that date?
April 17, 2024 at 9 a.m. in courtroom 1.
Thank you. Nothing further.
Good luck, Ms. Whiteskunk. Have a good day.
Thank you too.
And I believe that's it. Thank you, Deputy.
Chat, don't talk over me. Literally. Oh my gosh. All right, let's go to Florida.
Abreu Suriel.
Okay. All right, you were charged today with the battery, touch, or strike. Would you like to be appointed to the Office of the Public Defender today?
Sí, señora.
Yes, ma'am. Thank you, counsel. Would you like to be heard on any issues?
Yes, sorry, Judge, 1 second. Your Honor, we would do a PC challenge this time because there is nothing within the four corners of the affidavit to suggest that he intentionally struck her.
Last sentence where I'd look for that. It's the last sentence where she says that she slapped him in the face. She slapped.
Okay.
He slapped her in the face.
He slapped her in the face. Okay, so the inmates in here, they have enough going on. But it's the judge, guys, or the magistrate, or the judge, or the magistrate. I don't know what it is. She's the superstar here. You just got to listen to her. Just sit back and listen to her.
A paragraph, it's very, very at the bottom, and you kind of got to look for it. But it says here, following this, so they struck her on the side of the face with an open hand, causing redness and swelling and complaints of irritation to her face.
Okay. Apologies, Your Honor.
It's okay.
Fine, then.
At this point, I'm going to find there is probable cause for battery, domestic violence. State, would you like to be heard on any issues?
Yes, Your Honor. The state's fine with a bond, a reasonable bond, but no contact with the victim, no return to the home.
Thank you.
No alcohol.
Oh, alcohol was present. Yes.
He was drinking outside.
I saw that alcohol was prevalent. At this time, I'm going to enter a no contact. No contact means no contact. Hey, right here. Jose.
Sí, señora.
No contact, no contact.
Okay.
If you contact, jail.
Okay.
I'm going to give you a bond. But if you come back here because you contacted, not good.
Okay. Se lo prometo.
Right, I'm going to enter a bond for him for $500, no contact, one-time return with law enforcement if needed, no drinking, no alcohol, and no return. Thank you. Thank you. Deanna Daza Ortiz.
Okay. Gracias.
And I appointed defender's office. Right? Buenas tardes. Please state your true name and date of birth.
Diana Marcela Daza Orduz, 0,
At this time, you were
I'm
charged
a
with
professional.
battery domestic violence. Would you like to be appointed to the Office of the State Attorney, Office of the Public Defender today?
See? Yes.
All right, state that he doesn't, looks like he doesn't want to press charges. Looks like there was a battery, though. Defense, would you like to be heard on any issues?
No, Your Honor.
Said that there was a video where she smacked him in the back of the head. And he says, refused to prosecute criminally. They've been married. No domestic violence prior to this.
I do see that, Judge. I would just request no hostile contact then with the victim.
Does she have any history?
No, Your Honor.
Not gonna start with today. I didn't find there was any battery domestic violence due to the fact that there was no additional marks, pardon me, right here. Other evidence obtained, the sister refused to identify herself. She provided a partial video, so I didn't see the other portion of the video where it looked like the defendant or has indicated that he hit her. Did he get, is this at this time, court's gonna find an ROR, there is no battery domestic violence. Have a good day. Joan Garza Nalante.
Your Honor, he qualifies for pretrial.
Thank you. Oh, this is yes. Can you state your true name and date of birth?
Eduardo Garzón Sate.
Speak up, alto.
Joan Eduardo Garzón Alzate.
Juan Eduardo Garzón Alzate.
7 del
At this time, the court finds that there was, after reviewing a charging affidavit, that there was probable cause for the battery on a security officer. Would you like to be appointed to the Office of the Public Defender as your attorney today?
Sí, por favor.
Yes, please.
Thank you. Defense, would you like to be heard on any issues?
No, Your Honor.
At this time, state, would you like to be heard on any issues?
Just no return to the scene and no contact with the victim, Judge.
Thank you. So you cannot return to the bar where this happened at, which is La Palmas?
Sí,
No going back there. And you cannot be around Oscar, Ricardo, Javier.
You're going to have to be more
Emmanuel
specific.
Gonzalez. No, you cannot have contact with them. No contact with the co-defendants.
Okay.
Okay.
Do you understand?
Sí, señora.
Yes, ma'am.
And the bond, I'm going to enter a bond of $1,500. Oh, you said he qualifies for PTR?
Yes, Your Honor, he qualifies.
I'm going to give him PTR. No bond. Get it together. You need to
get it together.
Really work on this. You now haven't been in trouble before, and now you're in trouble for this.
Sorry.
Yes, sorry.
All right, thank you.
Okay, in a minute, you're going to be really worried if she ever went back and changed his orders too. His orders get changed. Don't worry. Don't worry about it.
I'm going to give him PTR, direct PTR without a bond. Richard Ramirez Romero. Oh, it's the same one. We all. Yep. Can you state your true name and date of birth? Good morning, buenas tardes. Good afternoon, buenas tardes.
Ricardo Ramirez.
You were here as you were charged with battery on a security officer. I do find probable cause after reviewing the charging affidavit. Do you want me to appoint you to the Office of the Public Defender for your lawyer?
Por favor.
Please.
Thank you. At this time, state defense, would you like to be heard on any issues?
No return to the scene, Judge, no contact with the victim, and it looks like this is the co-defendant, so no contact with that person.
Thank you, defense. Would you like to be heard on any issues?
No, Your Honor.
Thank you. At this time, I'm going to enter a bond of $1,500. No contact with the co-defendants. No contact with, let's see here, Javier, Oscar, Joan, Ricardo, Carlos Emmanuel Gonzalez, Ivan, Oscar Ivan Barboso Castro. None of them. Do you understand? You can't have contact. Oh, yeah, please. I love this one. Uh-huh.
Joan Garzón, Oscar Iván es mi employer, mis empleados.
Joan Carson and Oscar are my employers.
No hostile contact. That's fine. No hostile contact. You can still talk to them, but nothing about fighting, no fighting, talk about fighting, only talk about work. Do you understand? No hostile contact for the other one as well. For Joan, no hostile
See,
contact.
she changed it.
Oh, that's it. Have a good day.
Your Honor, can you advise the defendant he has a hold for immigration?
And you have a hold for immigration.
She let him ask one question, like, oh, this is good. I love this. Yeah, go ahead. He tries to ask another one. No, not today.
Let's see here. We are now Oscar Robert Amores. Can you state, buenas tardes, can you state your true name and date of birth? No contact with the victims.
Oscar Robert Amoros.
Okay. At this time, you're here for possession of heroin. I find that there was probable cause after reviewing the charging affidavit. Would you like to be appointed to the Office of the Public Defender as your lawyer?
Sí.
Thank you. Sorry, Madam Interpreter, what did he say? C, yes?
Yes, yes.
And defense, would you like to be heard on any issues? State, would you like to be heard on any issues?
Do not possess illegal drugs.
All right. Let me see, is this the Oscar? Is this the one? Don't possess any drugs. And I'm giving him a bond of $1,000. Thank you. That brings us down to Oscar Robert Amores.
Your Honor, he has 2 counts.
That was, 2 count, pardon me.
Sorry,
Driving while
sorry.
license suspended, revoked. The bond is going, I find there's probable cause, and the bond's gonna be $250. No driving while, without a valid driver's license. Alexis Negron Rodriguez. Thank you. Can you state your name and date of birth? All right, and you were here because you were charged with petty theft. I find that there was probable cause after reviewing the charging affidavit. Would you like to be appointed to the Office of the Public Defender as your attorney today? Would you like to have the lawyer, the public defender, as your lawyer today?
What were the charges?
Your charges were petty theft, stealing.
Okay, I did it.
All right. At this time, I do find there was probable cause, and thus the bond amount is going to be set for $500.
Okay.
Don't return back to Home Depot.
Okay.
Thank you.
Okay.
Bonded. Mental health, reset. Are you waiving, reset?
I'm sorry, Your Honor, which case are we addressing?
Okay, let's pay attention to what's going on.
Sorry,
You're at
sorry,
Jack,
sorry,
it's
sorry.
okay, Jaquez and Zell. Are you with me now? Jaquez and Zell, Ansel. Jaquez is in mental right now. I'm just gonna reset it. I'm gonna
I'm
reset
sorry,
it.
I'm hard of hearing, so I appreciate your patience.
Oh, I didn't know that. Well, you need to say that.
Well, now I am saying it.
Yes, yeah. Don't be
I
afraid.
appreciate your patience though.
No patience. I'll just speak aloud. No patience. You gotta say that. Speak up. Closed mouth don't get fed. Roger Clark. And now, guys, if you hear me talking up a little bit, that's why.
Thank you.
Of course. Roger Clark. Can you state your name and date of birth?
You have a
Thank you. You were here for failure for the defendant to appear. At this time, they have given you a no bond. It's another judge. Thank you very much.
Thank you.
Thank you. That brings us now to Patrick Oliver.
I'm sorry, Your Honor, the interpreter, I apologize for interrupting. Do you still need the interpreter, sir?
No, we don't. Thank you very much for your time.
Welcome.
Is this it? Is this the plea? Oh, sorry. Hello, can you state your true name and date of birth?
DeWarren Patrick Oliver.
Can you speak up into that microphone for everybody?
DeWarren Patrick Oliver.
Thank you very much. You're here as you were charged with possession of a weapon or ammo by a convicted felon, cocaine distribution, delivery within 1,000 square foot of a worship or a business, and larceny, other theft. Would you like to be appointed to the office of the public defender today?
Yes.
Your Honor, I have an argument as to PC.
Mm-hmm. Yes.
We have an argument as to the petty theft charge because there's nothing within the four corners of the affidavit to suggest that he stole anything of specifics from the Family Dollar, because the only thing that was mentioned is that he stole items from the store, and then it goes on to describe the other charges.
State?
State agrees. There's
I would agree.
any
Yes.
probable cause for the theft.
I would agree. So ROR on the larceny, other theft. ROR means that charges, that we didn't find that there was probable cause for them to have charged you with that. And then for any other, is there anything else, defense?
Oh, yeah.
I believe also the possession of. No, actually, no, Your Honor. I don't.
What are they saying is the knife? The knife, what they're saying is the possession of a weapon or ammo by a convicted felon. Are they indicating that the knife, a pocket knife?
Oh, actually, yes, Your Honor.
I'm not, sorry, that's my argument. I mean, is that not my argument? Is that your argument, counsel?
Yes, that is also my argument, is that it's a common weapon.
Yes.
It's not a actual weapon as defined in.
That's a pocket knife, 6 inches. A court's gonna find that that's a pocket knife, not a possession or ammo by a convicted felon. However, the cocaine distribution, delivery within 1,000 square foot of a business, counsel, do you have any argument?
Yes, Your Honor, there is nothing to suggest that it was within the 1,000 feet of the church or business, because there's no address mentioned.
Remember, you guys don't write them. But I don't see anything about the business, the church.
Yeah, when we get charges like that, there should be a measurement, but there's not. I would just request the court find probable cause for simple possession.
No, you find what? I'm so sorry.
Simple possession.
Yep, I agree. Because there was actually found on him, and so there will be, they said cocaine.
They did.
Dismissed. Have a good day.
I love her. Dismissed.
ROR on all 3 charges. Gotta have the charges right. Gotta have it right. Gotta have it right. Davy Medina.
Yes, Your Honor.
Can you state your true name and date of birth?
Davy Medina.
You were here as you were charged with a violation of a county ordinance. Would you like to be appointed to the Office of the Public Defenders today?
Yes.
Thank you. Defense, would you like to be heard on any issues?
No, Your Honor.
What was the ordinance? You gotta say what the ordinance is.
Open container, Judge.
Do you see that on here where they have indicated that that's the ordinance and that's the statute number?
I don't see a statute number, but county ordinance chapter.
I see it in here now. They just didn't put it on the front top page. All right, at this time, I'm gonna find that you violated the.
That is Natty Boh.
Open container statute. I'm gonna give you a bond, though. I'm gonna give you a bond of $150. Just don't drink the natty beer up. Just don't have it open.
No, I won't anymore. I learned my lesson.
Yeah.
I took
they
it
get-
away.
right. Yeah, $150. Have a good day.
Ma'am, thank you, Your Honor.
Excuse me, Your Honor, may I speak?
What's happening? No. We're here on
No.
Omari Stevens. Is that you? Okay, so now let me talk and then we talk. Okay? Can you state your true name and date of birth for me?
My name is Omari Stevens.
All right, you're here for larceny, other theft. At this time, do you want to be appointed to the Office of the Public Defender as your lawyer?
Yes.
Thank you. Counsel, would you like to be heard on any issues?
Your Honor, I believe there might be a PC challenge as to whether or not there is actual identification.
Whether or not it was
of
him,
at
right?
the premises.
State.
I'm sorry, I didn't really
Yes, I was just saying that there's a PC challenge as to whether or not it was actually him at the 7-Eleven.
oh. It looks like one of the witnesses were driven to an intersection nearby, Judge, and positively identified the defendant as the same one that entered the 7-Eleven and took the cough syrup and the Sprite soda.
Okay, at this time, does he qualify for anything?
No, Your Honor, he's out on ROR in case number 24MM4011957 for criminal mischief.
What's up? Hey, what's happening?
I didn't take any.
Don't talk about the case, though, but
No.
you gotta just get it together.
Get it
Your
together.
Honor, that misdemeanor case that he's already out on ROR on is not filed on.
Or
I gave him one because he needs it right now.
they never recovered the stuff. They said he took it, but. All right, I'm gonna find probable cause. At this time, I'm going to enter a bond for $150, and I'm not gonna take any action on the other case. Pardon? The public defender's appointed. Leslie Derek Kinsella.
And he qualifies for pretrial, Your Honor.
Thank you. Good afternoon, sir. Can you state your true name and date of birth?
Leslie Kinsler, 512 of 9.
All right, thank you very much. You are here as you were charged with battery, domestic violence. At this time, would you like to be appointed to the public defender as your lawyer?
I don't believe I would be able to have one.
Oh, no, the public defender doesn't cost money. Would you like to appoint that person as your lawyer today?
Sure, yeah.
Yes? Thank you. Defense, would you like to be heard on any issues?
No, Your Honor.
Seems like there's a victim, alleged victim. Ma'am, can you raise your right hand?
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And please state your name for the record.
Elizabeth Hetman.
You gotta speak up, ma'am.
Elizabeth Hetman.
Thank you. Ma'am, what would you like to tell me in regards to this situation on April the 12th?
It's a misunderstanding. I didn't call the police. I didn't feel threatened. It was a conversation that just got loud. And I don't understand how we got here.
Okay.
He's been out of the house for over 60 hours now. And he needs to take his medicine, and he's missed, days of it. And I don't understand. I haven't been able to get any conversation.
You gotta speak up a little bit. I can't hear you.
He's been
I heard he has been days without he's been out of the house for 60 hours now, and he cannot take his medication. I don't understand. Now you finish that, and you see how loud I said that, and you could understand every word I said. How about you try to do that now?
I don't understand how I haven't gotten any information as to where he was medically. He was taken to the hospital. Nobody would give me any information. I didn't press charges. I just don't
Do
understand.
you feel imminently threatened, ma'am?
No,
And did he hit you?
no.
Thank you. At this time, the court's gonna find that there's no probable cause for battery, domestic violence. State, would you like to be heard on any issues? I looked at the affidavit. She said that in her affidavit. Literally, she said,
I saw that, Judge. I don't,
Sergeant Lugo said, nothing physical happened between them. She tried to stop them from driving and leaving the residence during argument. I'm gonna find that this is an ROR. I don't find that there is probable cause for a battery, domestic violence. You can go home, sir. Thank you, ma'am.
State is having a bad day. I left just a tiny bit of his birth date in. Not all of it, because his accent was awesome. All right, this next one. What? What do you mean Australians don't drink Fosters? That can't be true. Is that true? Of course you live there, so I believe you. I do believe you. That's crazy. I did not know that. All right. We're going to try to decide this, guys. It is either attempted murder or it's just a vicious assault. Which one is it?
The victim stated that there was a copious amount of blood on her clothes, the floor, the walls, and the shower curtain. The victim stated that the next morning, the entire house was cleaned, smelling of bleach, and that there was no blood residue or any other trash from the incident. The victim sustained severe injuries, including a facial fracture, a skull fracture, and a broken wrist. The victim had to be transported to a trauma center because of her injuries. And with that, this state presents nothing further with respect to probable cause.
Okay, thank you. Mr. Bjorklund, just as a probable cause.
Not even close. It would have had to have been the purpose to cause the death of the victim. That's an attempted murder, Judge, to proceed with the purpose to kill another person. We don't have that from what I've heard, Judge, especially in light of the fact he takes her into the bathroom, he cleans her up, apparently looks at her injuries, but that's an aggravated assault. It's a second-degree aggravated assault, arguably based upon the injuries that this young lady sustained, but it's not an attempted murder. This defendant's purpose, based upon what I've heard, is certainly not to cause the death of the victim. He had every opportunity to kill her if he wanted to kill her. Hitting someone with your fist and then another object, he could have continued to bludgeon her in an attempt to cause her death. This is an aggravated assault at best, Judge, based upon what I've heard. I think the state really needs to prove, and they will be placed upon burden at trial to prove beyond a reasonable doubt that it was in fact his purpose to cause the death of this young lady. Nothing we've heard so far would establish that.
Anything further as the probable cause, Ms. Hoffner?
Yes, just briefly. Probable cause is a relatively low standard. This defendant said to the victim, "I might just kill you," hit her multiple times with blunt objects over her head that resulted in injuries that she had to be transferred to the ICU for. And with that, nothing further.
Mr. Bjorklund, anything further?
Judge, we already all know that, but it would have to be, you'd have to attribute those acts as an intent if it were an intent to cause her death. I don't see how they distinguish this from the intent to cause serious bodily injury. Where is the differentiation? Where would it be, that a reasonable person would have to conclude that he intended to kill her, to cause her death, as opposed to the intent to cause significant bodily injury? That's what we have here. It's unequivocally clear, Judge, and that's how this was originally charged, by the way, as a 1-1 with a second-degree aggravated assault. So I frankly haven't heard anything, even considering the low standard, to establish that these actions are tantamount to the attempt, and it's not a a reckless act on his part. It's not, I mean, even if it is, even if they allege that, you have to intend to cause. Your intent has to be that you're going to cause, your intentions are to kill the victim. I haven't seen that.
All right, anything further, Ms. Hoffner?
Nothing further, Your Honor.
Right, and as the state has indicated, as well as Mr. Bjorklund, it's a very slight standard in order to determine probable cause. It has to be based upon a well-grounded suspicion, and that's just a little bit of evidence. And intent can be inferred by conduct, and the court does find probable cause here to support each and every allegation of the complaint warrants, including attempted murder based upon the affidavit of probable cause, as well as the investigation report, which indicates that on the date and time in question, the defendant and the victim were at the subject property. The two exchanged words. She was then hit from behind from what she believed to be a closed fist, knocking her out of the chair she was sitting in. After that, she was hit about 5 times with unknown blunt objects. And at least one time was with a glass vase. After that, the victim indicated the accused drug her into the bathroom. When in the bathroom, the accused then stripped her of her clothing, sat her on the toilet, and copious amounts of blood were on her clothes, the floor, the walls, and then the shower curtain. The victim then stated the next morning the entire house was clean, smelling of bleach, and that there was no blood residue or other trash from the incident. Earlier on the night of the incident, while driving home from the Golden Nugget, the defendant indicated to the victim that I might just kill you. And the victim further stated to another witness that she was scared of him and he had become verbally aggressive at the casino. The victim stated that the accused carried pocket knives on his person and in his vehicle and is known to own a machete. And the victim stated the accused has told her multiple times that he has a gun in his car, though she has never seen it. So based upon that, the court does find probable cause to sustain each and every allegation in the complaint warrants, and will next move to the issue of detention. Ms. Hoffner.
Thank you, Your Honor. This defendant poses a great danger to the public and especially this victim of domestic violence. He also poses a risk of flight and a risk of obstructing the criminal justice process if released. According to the public safety assessment, the defendant scored a 1 on the risk scale for failure to appear and a 1 on the risk scale for new criminal activity. Despite the low scores, the PSA properly recommends no release, as the defendant's charges include first-degree attempted murder. In addition to first-degree attempted murder, the defendant is also currently charged with third-degree terroristic threats, third-degree aggravated assault with a deadly weapon, third-degree aggravated assault on a domestic violence victim, second-degree aggravated assault, a serious bodily injury, fourth-degree tampering, third-degree possession of a weapon for unlawful purpose, and third-degree criminal restraint. Despite the defendant's lack of criminal record, the facts of this case demonstrate that the defendant presents a serious danger to the community and especially this victim. The defendant told the victim, "I might just kill you," before unleashing a brutal attack upon the victim. He bashed her on the head with multiple blunt objects, one of which was a glass vase. The victim's injuries are so severe that she had to be transferred to the ICU. Having not heard otherwise, she is still in the ICU. The defendant's risk of obstruction is inherent based on the fact that the defendant and the victim are or were in a dating relationship. The defendant's risk of obstruction and flight is also evidenced by the potential sentencing exposure subject to NERA if convicted. The risk of obstruction is most clear in the defendant's tampering charge. The defendant had brutally attacked the victim before cleaning the entire house with bleach and throwing away items soiled with the blood of the victim that she shed in such a beating. All of which make clear, Your Honor, the defendant presents an obstruction risk in addition to severe risk of danger to the community and especially this victim. Therefore, the state asks that Your Honor hold this defendant.
Thank you. Mr. Bjorklund?
Judge, did the prosecutor say she was still in the ICU?
She was not clear about that.
Could you clarify that, please?
The last time that we had contact with the victim's family members, she was still in the ICU. That was as recently as Friday. I have not heard otherwise that she has left the ICU.
Okay, thank you. Judge, serious offense, low scores. I don't think he's any risk to the public. he scores a 1-1 and he's 31 years old, absent any criminal record whatsoever. No failure to peers, no pretrial detention, no probation, no parole, nothing whatsoever. This incident, Judge, apparently was fueled by alcohol. They were both consuming alcohol. Again, with respect to the weight of the evidence, I'll indicate to the court, when it's all said and done, I think what we have here is an aggravated assault. I understand the low standard as it relates to probable cause for purposes of today, but I haven't heard anything to indicate that it was his intent to kill her. She would not be with us anymore if in fact it was his intent to kill her. He actually rendered aid to her in the bathroom, Judge. If it was his intent to kill her, he wouldn't have rendered any aid. He would have continued pummeling her with the instrumentality as alleged by the state. So, Judge, I think that with respect to the weight of the evidence, at best, it's probably a second-degree aggravated assault with the intent to cause significant, serious bodily injury, which by no means, by all means, that's what we have here. We have significant bodily injury. He doesn't have any history of domestic violence. He's 31 years old. You would think that there'd be some history of violence in his past, which there's not. There are no simple assaults. There's no DVs. There's nothing, Judge. I'm not going to try and deprecate the seriousness. This is a very, very serious charge, Judge. It's a near charge, and I've explained all that to him, as well as explaining to him where I think the chips will fall ultimately with respect to the injuries. I don't have any of the medical records yet, but I don't have any reason to doubt that it's a serious charge. There's serious injuries. I certainly acknowledge that. He lives at 419 West Delilah Road with his mother. The whole family are lifelong residents. He's a car detailer by profession. Judge, this is a particularized victim. Again, it was fueled by alcohol. I think it was an aberrant act because there's nothing in his past to indicate otherwise. So it's not likely to occur again. He realizes under no circumstance can he have any contact with this victim. And he has no interest in having contact with this victim. And I know that she did pursue a TRO, and I undoubtedly will pursue a final restraining order, which is appropriate under the circumstances. But Judge, we still can't ignore the fact that they're 1-1s. It by all means appears to be aberrant because he has no history to support anything other than that. With this victim or any person whatsoever. For all those reasons, Judge, I'm going to ask the court to deviate from the recommendation, release him with appropriate conditions, the no contact provision.
Okay, thank you. Anything further from the state?
Just briefly, I just wanted to address a couple things. Firstly, I wanted to state that the PSI doesn't take into account all the facts and circumstances of the case. I see that he has low scores, but it's an algorithm, doesn't take into account the facts of this case. Additionally, there was a statement that the defendant rendered aid to the victim. As indicated by the police reports that were provided in the discovery, the victim didn't get aid until she was able to call for help 4 days later. And someone came and picked her up and took her to the emergency room. And any aid that the defendant would have provided the victim would be futile. She has a skull fracture. She has a facial fractures. Seeing that, yeah, so it was a friend of the victims that came to pick up the victim, not the defendant. And with that, I have nothing further.
Judge, I think that's also telling. It was 4 days later, and we're still going to indicate that he attempted to murder her. That was his intent, to cause her death. I don't think anybody even realized the significance of the injuries. I frankly didn't realize it was 4 days later until the prosecutor just told us that. But I think that's also indicative of the fact that they probably all thought that they were second degree injuries, or they didn't even realize the seriousness of the charges. So he has 4 days, it's his house. So 4 days later, he has 4 days to do whatever he wants to do. The court has the benefit of hindsight to see that if in fact it were his intent to do anything more than what he did, he would have done it, and he didn't do it. He didn't flee the jurisdiction. He didn't take off to Florida. He did no further harm to her. And I'm not deprecating the seriousness of what happened here, but it does directly go to what his intent was. I don't know what happened with respect to care between them. With respect to the facts and circumstances of the case, Judge, the algorithm doesn't take into account the fact that the state's not going to be able to prove an attempted murder here. They're looking at it as an attempted murder. That's why we went from a 1-1 with a recommendation of release to a 1-1 with a recommendation of detention based upon the charges. So that being said, Judge, I think the first PSI is really more relevant in that the algorithm does take into consideration all the other facts and circumstances, the lack of criminal record, and everything else in the triad for the court to make an educated decision with respect to release. At that, Judge, I'll defer. Thank you.
Softner, anything else?
I have nothing further to add, Your Honor.
Right, thank you. So I'm not going to deal with the issue of probable cause already, except for to note that, with respect to the attempted murder charge, the statement that the defendant made to the victim that he may just kill her weighs into this court's decision as to whether or not to detain and whether or not there's evidence that would support an attempted murder charge, at least for purposes of this detention hearing today. He may win the day when the matter ultimately goes to trial, or when the chips fall where they may in terms of the state's proofs, but that's not what the court's looking at for purposes of this detention hearing. So again, with respect to probable cause, I'm not going to deal with that again, but the court does find by clear and convincing evidence that no amount of monetary bail or conditions would reasonably assure the protection of the safety of any other person or the community, or that the
All right. Attempted murder or vicious assault. I mean, I don't think I agree with some of the things in chat. I think it's attempted murder. Oh my God, Casey is here. Is Casey here? Hey, yeah, you brought cheese. Yay. All right, now that we have cheese to distract us, come on, guys. Attempted murder or just aggravated assault? I got a murder. I got an assault with intent to murder. That's really cheating, Steve. You have to say murder or assault. Sarah says murder. Carolyn says murder. Chas says murder. Stink Eye says murder. I mean, he did Fozzie, aggravated assault. There's no trial or anything, so we won't know the answer right now. But all we're waiting for to see if he gets out or if he stays in. Maggie says murder. Jim of the North says he attempted to murder but failed. CRD says a murderous assault. People are cheating. Failed murder. That's what we should have. We should have a law for failed murder. I know what we do. We have attempted murder. But we should call it failed murder, because that makes them sound more bad, like a failure. You can't even murder people correctly. Go to jail. Steve says it's definitely attempted murder. I don't know how this lawyer can argue otherwise, because that's his job. I mean, he's doing a great job. That's what he's supposed to do. I mean, and that's her job. Her job is to do what she's doing. And when they get out of this case, those two will joke around with each other like nothing happened. And it's the judge's job to filter out the fluff. All right, here we go. Let's see if he gets out.
Defendant will not attempt to obstruct the criminal justice process. I look at the nature of the offenses charged: attempted murder, aggravated assault with a weapon, and tampering with evidence. The allegations are that the defendant severely beat a woman who is in a romantic relationship with, warning her that he may just kill her. And she also had knowledge that he did have weapons and had at least claimed that he had kept a gun in his car. With respect to the rendering of aid argument out there, that's going to be a difficult thing for the defense to argue. To me, it has every appearance that he was trying to clean up the scene of a crime and obstruct the administration of justice, especially given the fact that after the severe beating, he never took her to the hospital. He never rendered aid other than cleaning her up, along with cleaning the hospital, the room up. So the court looks again at the weight of the evidence against the defendant, which would include personal observations of law enforcement officers, statements of witnesses, the history and characteristics of the defendant, as well as, and the court did look at his criminal history, but the court looks at the nature and and seriousness of the danger to any other person or the community and the risk of obstruction here. And the court looks at the release recommendation in the PSA. The defendant's 24 years old. There is a recommendation of no release, albeit a 1-1 on the risk scale. There is no new violent criminal activity flag, but again, defendant's charged with attempted murder in a domestic violence relationship, aggravated assault with a weapon, tampering with evidence. He was observed trying to destroy evidence after the severe assaults, and the court finds that no amount of monetary bail or conditions will assure the safety of the community, which is a primary reason for detention, or that the defendant will not attempt to obstruct the criminal justice process, which is a secondary reason the court finds that the state has overcome the presumption. Sir, you have the right to appeal this court's decision ordering your detention. You have 7 days to do that. You'll have the opportunity to discuss it with your attorney prior to deciding whether or not to move forward with an appeal. Your next court date looks to be May 20th. That's before Judge Darcy. And I believe that's all we have in this matter.
Thank you, Judge.
All right,
Thank you, Your Honor.
Good
So
luck.
you can leave the booth. Mr. Churkovan, you can leave the booth. Judge, you want me to unmute him?
No, Judge, I don't need him saying anything. Mr. Turkoman, you're done here. We'll talk further, okay? Thank you.
You're staying, sir. Yes. You were detained.
You're detained, yes.
Casey, you should design a blood cleaning Roomba. It'll be popular. Judge Darcy in I think Colorado, Cha. I don't think this is this definitely isn't Michigan or anything like that. I did too, because I was looking at chat. But no, if this is Jersey, this could be Jersey. If it's Jersey, there's no bond. They got rid of bonds in Jersey. Kind of like you either are released and you have conditions, or the DA, or the prosecutor says you have to stay in, and then the judge can't even change that, and you have to stay in. And this might be Jersey, and that's a beautiful courtroom, look at the light. So Jersey's just different now. It's just weird. You either are there or you're released with conditions. True, Maggie. All right, it's time for Fleischer. It's time. We've had enough funniness, enough normal courtrooms. Let's go into where everything should be.
Okay, so is it Ishola? Mr. Ishola, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir. All right. Good point.
On April 7, 2024, in Harris County, Texas, traffic stop was conducted on a vehicle for failing to signal a lane change and not having a front license plate. Defendant was a driver and sole occupant. Officer detected a strong odor of marijuana coming from the vehicle. Defendant stated he had a gun in his pocket. Defendant was detained. Officers recovered the gun from defendant's front pocket. Search of the vehicle located marijuana in the center cup holder. Defendant was in possession of 3 Texas driver's licenses. 2 had the defendant's correct information. 1 of them had a different ending than defendant's assigned driver's license number. The color was different and they had a different date of birth. Officer ran the driver's license number and found it to be returned to the complainant, Donald Blum. Complainant was contacted and stated he does not know the defendant. Defendant did not have permission to have the complainant's ID information.
Okay. Mr. Inshallah, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license in your name? Do you have valid liability insurance in your name? Correct.
Car insurance?
Correct.
Yes, sir.
I want proof before I allow you to drive. Otherwise, I'm ordering you as a condition of your bond not to drive without valid insurance in your name. If you do, if you violate this court order, because I'm going to have you sign an affidavit promising me that you're not going to drive without valid Texas driver license and liability insurance. If you do, you'll be facing a contempt charge and an additional 6 months in jail and a $500 fine every time you drive. What do you do for a living, sir?
I do stocks and I also do information technology.
How old are you? Did you graduate from college?
Houston Community College, 2 years.
How much money do you make a month?
I make about $8,000 a month, sometimes a little bit more, depending on how much I make.
We're going to reset your case to give you time to hire a lawyer.
Already have a.
Oh, you do?
Yes, sir.
Who is it? I'm sorry?
Brian Levine.
Got it. Let me see if he's filed any kind of documents saying that he's going to be here today.
I see he's on the tampering charge of the felony court, but I do not see anything yet.
Have you talked to him today? Is he going to be here today? Do you know? Okay, so let's do this. I'm going to have you go to Victoria. I'm going to have you go to Victoria now. We're going to have you sign a reset. After that, I'm going to have you take a seat in the jury box while I get your bond conditions. Do not leave until you sign your bond conditions. I'm also ordering you not to be in possession of any weapons as well. Don't violate these conditions. Don't pick up any new cases. Otherwise, I'm going to put you in jail. You understand? All right, please.
No weapons, Your Honor.
Just no weapons and no driving without a valid Texas driver license and liability insurance.
All right, page 24.
You show he's eligible, though, right?
Kilo.
Okay.
Come on up.
Okay, I'm sorry, who is this?
Page 24.
Laszlo Villa? Mr. Villa, you're charged with operating a massage parlor. I'm assuming it's without a license, correct? Yeah, Villo, V-I-L-L-O. Yeah, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Have we done? Do you see, look in deeds, it says there's a no driving, bail condition, no driving from 4/9/24, but something else pops up.
They just mislabeled it, Your Honor. It's a cash bail bond.
Right, okay. All right, well, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir. Give me 1 second. Hold on.
Hey, David, good morning.
Hey, I'm about to do PC with Mr. Villo. Do you want to be here?
I would like to be there, yeah.
How far are you?
I'll be there in about 15 minutes.
Okay, I'll just have you take a seat now. When your lawyer comes, we'll do it.
Okay.
Okay? All right, thanks, Jose.
thanks.
Bye.
All right.
Just go ahead, take a seat for me in the front pew. When your lawyer gets here, we'll do it.
That's it for our ratings so far. All right, so page 25, Wade, come on up.
Riley Wade. Mr. Wade, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On April 7, 24, officers were dispatched to a motor vehicle accident in Harris County, Texas. Defendant was observed to have red glossy eyes, odor of alcoholic beverage. HGN, the suspect had both left and right lack of pursuit, distinct nystagmus and onset of nystagmus clues. 3 clues on a walk and turn, 0 clues on a 1-leg stand, DIC red, consistency of breath, 0.107, 0.104.
What was the stop for? I missed it.
What was that?
Stop.
Accident.
Okay, so they came up on him.
Was dispatched to a motor vehicle accident located on 160 West Gray. Officer made contact with defendant, later identified as this defendant Riley Wade, found to be in the driver's seat of the vehicle. He had collided with another vehicle at the location.
They smell alcohol?
Yes, Your Honor.
Got it. Okay. All right, Mr. Wade, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license? Can you run his license, please? Do you have valid liability insurance in your name? Are you sure? You may not drive unless you have both. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or dope, you will go to jail. You will not get any more PR bonds. You understand? How old are you?
27, I'm sorry.
What do you do for a living, sir? How much money do you make a month? We're going to reset your case to give you time to hire a lawyer. So I'm first going to have you go to Victoria. We're going to have you sign a reset. After that, you'll get with Jeremiah for your bond conditions. After that, we'll let you go. Beware that if you like your license, there's a lot of timing requirements with the DWI. So in your search for a lawyer, I wouldn't take months to do it because you may suffer severe consequences with your license. Do you understand? Please. Great. Any more? Any THAs? No? Ms. Basu, who are you here on?
Petrie James, come on up.
Oh.
I'm Abraham Al-Kurdi judge.
19.
Who are you here on, ma'am?
Last name is Abraham and first name is Al-Kurdi.
You just be on the.
I see it.
Judge, last name is Alcordy, sorry.
I see it. Has your client completed all that he's supposed to complete?
Yes, Judge, I forwarded everything to the ADA this morning, Christina Rodriguez.
Could you send it to me?
Do me a favor, will you send it to Pavel, please? Because she's out of the office, or she's not here today.
Sure,
So
sure.
I can chat you his email address.
That'd be great, Judge.
It's your last name first, right?
Yeah, PETROV_PAVEL @DAO.HTTS.net. Once I get the email, I'll dismiss it.
That's
Okay,
it.
thank you so
Go ahead,
much.
send it now. We'll take care of it for you.
And Judge, my client is in the courtroom. Should I have him wait or can he leave?
Yeah, as soon as they file it, I'll let him go.
Okay, thank you, Judge.
Yes,
Okay.
ma'am.
you
So
have a
just
good day.
send it and then I'll give you the heads up, okay?
Okay, will do.
Mr. Petrie, do you have a lawyer today?
I'm here to request more time. I did start a payment plan with the FSY group.
It's too late. Your case is 190 days old and it's time to do something with your case today. So I'm gonna appoint your lawyer today. We figure out today what happens. Go ahead, take a seat for me in the jury box, sir.
Can I get them to sign?
No, I don't know if we're gonna, it's 190 days old. You know what I mean? Yep, take a seat for me, sir.
Page 20, Rivera.
Macario Rivera.
He's a Spanish speaker.
Oh, espérame un momento.
Oh, that's it, the last one, right?
Laura AE, who are you, ma'am?
Yeah, one.
Laura AE, if you don't identify yourself, I'm gonna take you out.
On a date, or he's gonna light you up.
Hi, come on up. Good morning.
Judge, I've got a petition for an occupation of driver's license on Mr.
Okay, have you spoken to Ramona? Ramona,
No,
help.
Judge.
If you want to go back, she's back there now. She can help you out. Thanks.
Thank you.
Thanks, Ramona. Chisholm.
Good morning, Judge. I'm sorry, I'm just
Hey, good
entering to
morning.
the office now. Yeah, I was emailed about Miss Mathis.
Miss Mathis was the one from yesterday. She had court yesterday, and this is her lawyer, and she was here, and she was supposed to sign a reset, which I have no idea what that means, but that's okay. I think it just means the next court date, that she acknowledges the next court date. She was supposed to sign a reset before she left, and she didn't sign the reset. So the judge revoked her bond and put a warrant out for her yesterday.
That's the one that left without signing.
Yeah, she left without signing her stuff.
Now, I will take complete responsibility because we walked out together and I was under the assumption that her recess were just Monday and Thursday. That was my assumption and hers as well. So when she left, I didn't get her number yet. She just called me today and was like, hey, I'm headed to court. Do I take the UA there? And I'm like, well, it looks like you might have a warrant out because you were supposed to get your reason. And I didn't even know. So that was my assumption and hers as well, that we were just going to appear in court Monday and
Our
Thursday.
our staff told her to wait.
Now, I mean, I recall both of us walking out together and explaining the whole process to
Yeah.
her. So I didn't
She's
see
suppo-
that
is she-
happen.
She's supposed to be here regardless, right?
Yes, Judge, she is coming. Yes, Judge. We
Okay,
spoke this
so
morning.
let's
She's
get
on
her
her way.
here so we can go send her for a drug test.
Yes, Judge, I appreciate that. Would she still have that bond revoked?
I'll reinstate it momentarily.
Yes, Judge. I appreciate that, Judge.
She needs
Thank
to
you.
go, she needs to go right now to go take a drug test.
Yes, Judge. She'll be there. She'll be there. Does she come to court first?
I am, I will. What's
So
that?
she goes to court first and then she'll go to take the UA.
Yep, I'll reinstate it right now. She's got to go take it
Yes,
right
Judge.
now.
Absolutely. I'll let her know that right now. Thank you so much, Judge. May I be excused?
Yes, ma'am, thanks. Okay, Mr. Villa, we're back. Your lawyer's here, so we're gonna do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
Your Honor, so on this case, on March 27, 2024, HPD Vice was conducting inspections of massage establishments. This one, traditional Thai massage located at 101 Obion Road in Harris County, Texas. Officer went inside and met with the defendant and Chanita Villo, who is the defendant's wife, and the massage therapist at the establishment. Investigation of the establishment showed that it was operating without a required license. Chanita Villo was also arrested for prostitution.
How do you connect him to anything?
He's on it. So I can read the whole PC if you want, but okay.
Yeah, I find no connection to him so far. The wife is working, right?
Yeah, he's there. So officer is assigned to Vice Division, conducted inspections of business establishments for Harris County regulations, March 27th. Vice undercover officers conducting a massage establishment investigation at traditional Thai massage. Went to traditional Thai massage therapy, found that the business operating as a massage establishment. Officer found the massage establishment was open for business and to meet the requirements for a massage establishment as defined by Texas Occupational Code, Chapter 455, Section 455.0015. The term, I don't care about that. Officer went inside the traditional Thai massage therapy and met with defendant Laszlo Villo and Chanita Villo. Officer conducted a non-custodial interview with defendant Laszlo Villo and Chanita Villo and found the business was being used as a massage establishment. Defendant Laszlo Villo admitted to being the business owner of the massage establishment, traditional Thai massage therapy. Chanita Villo admitted she's an employee at traditional Thai massage therapy that gave Thai massages in the business in exchange for a fee. Officer found that Chanita Villo met the requirements of massage therapist under 455.0017. Officer conducted an inspection and found posted on the wall a certificate of completing 12 hours of Thai reflexology at Harmony Thai Massage Center issued to Chanita Villo, along with massage therapist license issued by the Texas Department of Licensing and Regulations, issued to Soysala Futima, that expired last year. Van Narin Ferraro expired February of this year, and Amitarat McCorkle expired December 20th, 2024. The officer found posted on the wall a massage establishment license issued by the Texas Department of Licensing and Regulations for traditional Thai massage therapy located at this location, expired May 23rd, 2023.
So they did have one. It had just
It
expired.
expired.
Okay. So please, I'm going to find that there's probable cause, Mr. Villo. Please do not operate this establishment until you have a proper license, okay? Because otherwise you're just going to end up going back to jail. You have a lawyer. Jose's great. He'll take care of you. Just listen to him and then things will turn out well for you. I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Sahan. He'll tell you if and when you have to come back to court. If he comes back to me and tells me he can't get a hold of you because you're playing games and not answering his phone calls, text messages, I will issue a warrant for your arrest. Don't pick up any new cases and stay in contact and you'll be fine. We'll have you sign a reset and then we'll just get you out of here, okay?
Thank you, Judge. Whenever you give me that license or renewal or whatever, just let me see it. And then, sounds good. Yeah.
All that condition, I guess.
So no operating without a valid license.
Yeah.
Yeah.
That's why they was
Anna, were you lucky?
So we resubmitted the contract on Friday. The Ms. Simon, the woman who's in charge of the program, she's in a meeting at the moment. She's gonna call me as soon as she gets out, and then we'll have
We
it.
just had Nathan get his client an appointment.
Oh,
So somehow they were able to do it.
okay. Well, let me,
Eric
I'll talk to Eric
was
and,
able to make an appointment for him.
It was done on April 9th, Your Honor, and that was actually part of the bond condition, so it was through the court.
Yeah, sorry, that didn't come out.
That's through the court because it was a bond condition, so.
okay.
Then maybe we should do the same thing for him because he's unable to make one. Like we're
Sure.
pulling teeth trying to get him to make an
You
appointment.
can make it a bond condition now.
Okay,
Okay,
I'm making that a condition of his bond that he makes an appointment at the Harris Center.
okay.
That's the
And
only
he's
way.
Trying, Judge. I mean,
I'm not,
okay.
right, but we're beating a dead horse here because it's just not working.
So we can, I guess, modify it through him, and then at that point, that bond
Okay,
condition.
let's do that. That's the only way. So remember, do you remember the gentleman on Friday that we made a condition that he make an appointment at the Harris Center to get the mental health evaluation?
Justin Broussard?
Broussard, it's on docket today. I can give you a cause number.
I'll talk to Jeremiah.
Okay, thanks.
He was the one that just said, give me a year, send me to jail.
I know, but Nguyen is unable to make an appointment, but since we made a bond condition for Broussard to make the appointment, it got done, whereas he's unable to do it. So now we're gonna make it a bond condition. Okay.
Your Honor, this is Mr. Florida.
Okay. 3 days, 5. All right, Mr. Flores Cuellar, you're charged with driving while intoxicated. You're also charged with criminal mischief. Is one being dismissed or what are we
Yes,
doing?
the criminal is being dismissed, Your Honor.
Okay, you're only facing now the DWI. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequence. You can be deported, excluded from the country, denied naturalization under federal law. You're giving up the right to appeal. So once you accept this agreement, you can never change this. You understand?
I don't understand, sir. What do you mean?
You're pleading guilty to this offense. It's going to go on your record. You understand?
Sir.
I want you to also understand, Mr. Flores, is that if you get pulled over, an officer will see this on your record. If you smell like alcohol or dope, they're going to immediately arrest you just because of this DWI that you have now. So I would never get in a car if you've had anything to drink because you will absolutely go to jail. Don't matter if you're drunk or not. Do you understand? From now on, you're facing a minimum of 30 days in jail if you ever pick up another DWI. Do you understand?
Sir.
Once you do this today, you can never change this. You cannot come back and say, you know what, I changed my mind. I want to do something else. Once you plead guilty today, you're stuck with this forever. Understand?
But I can still drive after I get out of here.
No, because I have to suspend your license because of the law.
I never had one to begin with.
Okay. Well, then don't drive. You ain't got a license.
He said that.
Mr. Flores, don't drive until you get a license. I'm going to suspend your license for 180 days. If you want to drive, talk to Marcos. He can tell you how to get a license. Or come back to me. I will help you get a license, Mr. Flores Cuellar. We will call DPS for you. Do you understand? How do you plead to the offense? Guilty or not guilty? I'll find you guilty. I'll follow the agreement. Good luck to you, sir.
Thank you, Judge.
Thank you so much. Thanks for coming, Marcos.
No, thank you.
Ready?
Yes, sir. Eric Moreno Zavala, and he has a TRS 430.
When is it?
430, April 30th.
Is he here now? You want to go send him now?
We can, that's it.
Might as well, instead of waiting an entire month.
Well, 2 weeks, but whatever, if that's what you want to do.
Oh, yeah, it's 4:30. I was thinking it was, do you guys have turned everything in?
I don't know. I'm coming straight from my kid's school, but I think it's one that I actually wanted him to try and he wanted to do the PTI, so I think it's not good.
Pavel, can you tell me if Moreno Zavala has turned everything in, please?
Of course, Your Honor. We look on here.
Council for reset.
He has a disturbing case coming up soon. You might want to fast
PTI was
forward
already
through.
approved.
So do you have the application though?
Let me check on the application, Your Honor. It would be attached.
Come up, Mr. Moreno.
Judge, that's not gonna be hard. If the application hasn't been turned in, that'll take us like 5 minutes.
Okay. Sir, we'll set your case off for 2 weeks for you to do your evaluation. You must have the application submitted by that time. All right?
Yes, sir.
Okay, great. We'll have you sign a receipt. We'll get you guys out.
You want him to, so you reset him 2 weeks to do the evaluation in 2 weeks, or do you want him to go over there now?
No, it's, if you want, it doesn't matter to me, whatever you want.
Yeah, I mean, I tend to prefer to do the walkthroughs when I'm having trouble and he's.
That's okay. I'm all right. I'm with you. That's okay. All right. Please. Thanks. Not happy with you. And I'm gonna tell you now, you pick up another case, you violate these conditions, I'm going to triple all of your bonds. At some point, someone's gonna stop paying money to get you out. Because every time your bond gets revoked, whoever's ponying up this money loses that money. Do you understand? I'm now ordering you because I think you have a pill problem. I want you to start doing AA and NA classes now. And I'm also going to order drug testing for you weekly. The next time you test positive or you have a gun, I'm telling you, I'm going to put you in rehab in the jail. Do you understand? The worst thing you can do is get addicted to pills, because what happens is you build up a tolerance. And at some point, what you do, your body becomes accustomed to it. So to achieve the same high, you keep taking more and more and more, and you will put your lungs to sleep and you will die without even knowing it. That's the problem with pills, is you put your body to sleep unknowingly. Do you understand? Jeremiah, weekly drug testing. Yep, let's just send them right now. So AANA 3 times a week, must provide proof of attendance. You must go to these classes. You must provide proof of attendance. You can do it online, but I want some kind of proof showing the attendance that you've been there. If you don't, I will put you in jail. You understand? No drugs, no alcohol, no weapons, random testing, and AA. As long as you can abide by these conditions, you and I will be best friends. Otherwise, it's just not going to go well for you. All right. Thank you. So what we'll do is from today, we'll give you 30 days out. We're going to set him here all the time because he's going to have to come back and do drug testing. You don't have to appear with him every single time. So for you, we'll just set you 30 days out, but he's got to appear here so we can take him for drug testing. We'll carry him together. Yeah. No, he stays with me. So I can monitor and make sure he's doing well, because he don't get monitored over there. I'm going to keep you with me. Okay. Thanks, Sonia. Okay. Hi, who's this?
Joshua Albers.
I'm trying to remember, guys, because there were so many people in front of him, but this might be the disturbing one. So if you want to go make a sandwich or something and then come back, and then unless I'm wrong, and then you're going to have to go back later and make another sandwich.
You said 3 for 14, right? How old are you, Mr. Alvarez?
26 years old.
No. Had you just, all you had to do was show up. Had you shown up, you probably would have ended with a
I was
pretty
wrong.
good
He's
result
fine.
in court. All you have to do is show up and just behave yourself. Because of your failure to show up, you will now end up pleading guilty to this case. One day in the future, you're going to remember this day and say, why was I so damn boneheaded that I couldn't even show up? You're now pleading guilty to an assault of a family member. This carries with it an affirmative finding of family violence, meaning that you will never, ever be able to own a gun or ammunition for the rest of your life. Also, if you ever pick up another one of these cases, you'll be facing up to 10 years in prison. Even the slightest grab of an arm where you hurt someone, you'll be facing a minimum of 2 years in prison, a maximum of 10 years. Do you understand?
Yes, Your Honor.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen or a possible immigration consequence, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this, undo this, challenge this. You understand?
Yes, Your Honor.
How do you plead to the offense?
I plead guilty, Your Honor.
I will find you guilty. I will send you to 3 days in jail. I will give you credit for the 14 days. Like I said, there's an affirmative finding of family violence. When you pick up another one, you will be doing many, many years in prison. Good luck to you, sir. Thank you, Alan. Nathan.
Client is Afton Diceberg. One additional recent.
Page 5.
Her blood draw was.
We've given more time since February.
She has extenuating circumstances, right?
Where is Miss Deesberg? Okay. Come up, ma'am. Tell me, what's the extenuating circumstance?
Your Honor, last June, her fiance was murdered and died in her arms, and she was bludgeoned. She was stabbed several times. She was sent here from Alaska through crime victims, and so she has had a lot of trouble sleeping. She did this one situation with this alcohol. She drove while she was intoxicated, and but she's now seeing a psychiatrist. In fact, you have an appointment on the 23rd. So we've been working with the prosecutors in Alaska, and they're sending documents. We want to get a real good packet together. I spoke with Mr. Beadle, who indicated that if we could get a really good package, she has a chance to be in the program. She has no prior offenses. And you just need one more time.
Have you approved her or no?
I have not, because of her high BAC. That's something judge, she needs to approve.
What is the BAC?
0.268.
But I have to, it's 200 days and I have to put a limit on it, you know? So you tell me when we can have all this done.
We just need.
Yeah, I mean, I think you can get it done in 2 weeks. Yeah.
We can get it done in that time.
Okay, I'm fine with that. You know, the thing about it is if we all have issues, right? We all have issues, but it's not fair if you have issues, if I have issues, to put others' lives in danger because of those issues. You're right. If you want to get lit to where you have a 0.5, wonderful. Stay the hell home. Don't go out. And if you have to go out, in 2 minutes, 5 minutes, one button, you have a car waiting for you. $20 will take you anywhere. It's a geographical oddity. Anywhere you want to go for $20, it don't matter where you want to go. It's not fair. I will give you 2 final weeks. You must have everything done and turned in by that time. Once you do, we will send you to go get a TRAS done. And then after that, we'll give you more time to get the rest of the stuff done. But you must have everything turned in by that time. Okay? Okay. Thanks. Please.
Thank you.
Of course. Mr. Petrie, your case is now nearly 200 days old. It's time to make a decision. I will give you and your counsel now 1 reset to go through the evidence to see what you want to do. They've offered you time served at this point, so you guys can discuss that. When you come here, you must make a decision on what you want to do. If you do not want to accept the plea bargain, I will set your case for trial at the next setting. You understand? All right. Good luck. Thanks. Hey. Hi, Hugh. How are you, man?
Dominic Brino.
Brino, okay.
And this is his first setting. He was taken remanded into custody about a week or 2 ago.
Let's see, I always. So remind me, is it he violated conditions of bond?
It was, yes, it was for the curfew. And then he was taken into custody and then he bonded.
Same thing, we'll go back to normal, okay? Let him know that if he violates again, he's here, right? Come up, Mr. Greeno. You know what's expected of you. The same thing will apply. The next time you try to play a game with me, I'm going to triple, if not quadruple your bond. I'm not going to play this game with you. And if you become too high maintenance for me, I'm just going to set your case for trial and be done with it. Do you understand? You pick up a new case, you violate conditions again. You're forcing my hand. Okay, guys, thanks.
It's not first time mother is a stepmother of her son. There was a custody battle going on. It's a very highly contested one. So it doesn't surprise me that she is reaching out saying this. And then unless there is something else that you have substantiating this, Your Honor, this is just throwing mud. As far as I'm concerned, they're trying to take her son out of state, which is a pretty big deal. And it takes
My only concern is that if in fact she is driving, come up, Miss Velma.
And I asked her who's transporting her son. It's her grandmother who is more than willing to vouch. Her grandmother transports him and so does her mother, but she has not been driving.
Lies.
You to read that letter.
And it is the same individual that has been.
I don't care. My only concern is if she's driving, so help me.
Yeah, they're doing a lot. They've also called CPS, which I haven't even had my son, and they're calling CPS and telling them a lot of this is.
Which is probably with your criminal history.
I understand.
Rightfully. I mean,
I understand.
Put yourselves in the shoes of someone else, right? Would you want a baby in the custody of someone that has that kind of criminal history? You know? Really?
His father has criminal history as well, and
you're trying to justify it.
If you just can give me 2 seconds. I've never used that against him. I lost my daughter from a different father, so he doesn't know anything that I've been going through. My brother killed himself in 2016 in the parking lot of the Harris County Sheriff's Department on Clay Road. I don't know if you heard about it or saw the news article.
I understand that you have issues. I get it. I get it.
But what I'm saying is, I've never used any of that against them. I've been very amicable with them.
We're having two different conversations. We're having two different, like, what I'm trying to impart to you is that you're talking about custody, right? And I am too, but I'm talking you having custody of someone. What matters is, and you know, when you're single, it's all about you, right? You can do whatever the hell you want to do. You can go here, you can go there, you can stay out up 3 days, doing whatever you want to do. When you get married, it's about your significant other, right? You always think about your significant other because that's what a marriage is, right? It's a chain link fence. And when the link is broken too much, the fence falls apart. When you have a kid, it's not about you. It's not about your significant other. It's only about the baby. Nothing else matters. And that's why two people who cannot get along, who have drug issues, have no business bringing another life because they can't even take care of themselves. And you, with the baggage that you have, while you may be a great person, there's too much drama, too much PTSD for a baby to put into the mix. Because everything that you do will impact the baby one way or the other. I don't care what they've done. I don't care what they're doing. I don't care how many cases. You are the one that has the baby. You need to make the sound decision. I know you don't have the baby, but what I'm telling you, if and you do at some point, my concern here is public safety. I don't care about your baby. I don't care about your grandmother. I don't care about your husband. I don't give a rat's ass about anything about that. But with you, DWI, FSGI, retaliation, DWI, assault of a public servant. That's why I have my eye on you. And when I have someone telling me that you're driving now repeatedly, I have a big problem with that because I've ordered you not to drive and I had you sign an affidavit. And so help me, if I find that you're driving one way or the other, I'm going to freaking lose it. You better not be driving. I don't care what is going on in your life. I don't care who you have to pick up. Do you understand me? Tell me, has she done the AA&A that she was supposed to do?
Yes, Your Honor. I think because there is no transportation, no driving, and the mother works 12 hours a day, the grandmother works, the grandfather works. I think you suggested her going online, which she did. I know that didn't turn out to be suitable. I told her to find something near her. She could go something in person where there is a sign-in sheet. She actually now has a sponsor. This is the place she's attending now. The sponsor's name's on the back. It's the first name, Rebecca. Rebecca is suggesting, since she's early in her treatments, that she suggests she go once a day, every day. She wanted her to go today at noon. She told her she was going to be in court. But she also is willing and in agreement to go every day. She likes this person. And so I think this is going to be her new place. She went to one other place as well this weekend on Fry Road, which isn't too far. There was no sign-in sheet. She got somebody to sign this little paper.
This is a schedule. This doesn't tell me that she's attended, though.
Right. I know.
Do we have any proof that she's done anything?
She went to, she got her.
I don't care about that. I told you to bring a sheet of paper signed. Did you do that?
I got one printed out. My mom works on Saturday and Sunday from 9 to 9, so
Do you have anything here today with proof that you've gone to any AA meetings or NA meetings?
you get these chips, and that's my sponsor.
Revoking your bond. She goes with you, please. I'm sorry, Joaquina. I've more than enough. I've literally. That's it.
Yeah, and I know one of the places they said because of anonymity, they couldn't give her a copy, it was everyone's names on it.
That's not true. It's not true. It's, I mean, I'll give this to you. I don't know.
I'm not allowed to pause the video, guys. Don't make me pause the video. People get really mad. And then I'll get comments, especially if I pause the video for no apparent reason, right in the middle of a good part.
We have Mr. Broussard set today, who is our mentally ill man who randomly assaults person.
Yes.
He is currently okay, sorry.
So
Our office reached out to the facility that he's at. No answer about whether or not it's there. They won't confirm any of that. They haven't got back. Finally got into the intake department of the facility and has not been able to get an answer.
With HIPAA, they'll never confirm unless there's multiple steps, but we can't.
So let's do this then. I mean, reach out to the family. I'll put this on for Thursday. And please say if you can get some kind of proof that he's actually enrolled.
Yes, Judge.
And if he is, then we'll give a long reset. If he's not, then.
Usually with these facilities, I can get somebody eventually to confirm it on the phone, getting a piece of paper out of them.
I trust you. If you can confirm it on phone, I absolutely 100%. You're an officer of the court. I trust you is 100%. So
We'll push a little harder.
I'm okay with that. So Broussard, SFBF Thursday, please.
If we find out before, we'll.
Just let me, yeah.
We'll do, Judge.
Yeah, for sure. Mr. Foreman.
Good morning, Judge. I'm here on World Pesa.
Yes. It's only 23 days old.
So her felony case was dismissed this morning and the state is dismissing the misdemeanor as well.
Okay,
I'm
great.
only approaching, there's a MOA in place on her on this case, and so I was gonna ask if we could have the MOA removed.
What's your position?
Judge, we can modify the MOA just because it's been dismissed. The reason for dismissal is we don't have a cooperative complainant. So.
What do you, I mean?
We haven't get a hold of him to even ask, his feelings about communication. So.
I mean, if they're playing like that, then okay, I'm okay with it. So I'll put here, take off MOA. Okay, for sure.
Thank you.
Thanks, Amy. Hi, guys. You ready?
Mr. Blackburn, Your Honor.
Morning, Mr. Blackburn.
Good morning.
So you're wanted out of Choctaw Nation.
Yes, sir.
I'm only asking you to do one thing. Actually, you can do one of two things, because from what I understand, there is a bond, right?
Yes, Judge.
It's 10,000. If you were able to post bond in that case, this case against you here, this fugitive case gets dismissed. So I don't know if it's more worth your while to ask your family to see if they would, instead of ponying up the 5,000 here, to use that to post the bond up there, which would get this thing dismissed, versus if you post it here, you still have to get out there and go either post it or turn yourself in.
So I don't understand. When I first got here, they were saying yes, that I had a bond there, that I could bond out. And when they're looking everything up online right now, it's showing that there's not a bond available. So I don't.
In Choctaw Nation.
Choctaw Nation, yes, sir. So
And maybe there isn't. I don't know.
I mean, I've been.
think what it is, here's my 2 cents. For some reason, there's a $10,000 bond and then there's a no bond because there's two charges.
Could it be that there's a 10,000 bond on one case and then no bond on the other?
That's what I'm thinking. Because I don't see that, I mean, from what we've discussed, and of
Yeah.
course, I can't verify any of this. If he hasn't been booked in on the assault corrections
So-
case, that wouldn't, he wouldn't have a bond and be a warrant type status.
I am gonna pause it because KC says it's that lurch behind him. That's that guard that took down the soft set. But I have a burning question about that guard right there. And I have a lot of Texas people in my chat right now. So I'm from Pennsylvania. Okay. So what I know about Texas is, you know, it's hot in Texas. It's not cold. I mean, it got a little cold, in a couple years ago, and everything broke. It was complete chaos. So please tell me, can someone please tell me why he has a thick coat on? Is it cold there now? He has a thick coat on. I mean, that's fine for Pennsylvania, but this is Texas. All right, keep going.
I don't know.
But we've talked to him about when he goes, he can do a walkthrough bond or go and turn himself
Oh,
in
yeah,
set
no,
bond
that's,
and-
yeah, that's my intention.
It's up to you, whatever you want to do. We give you 2 weeks from the date of your release here to go do one of two things. You must turn yourself in, or you have to post that bond and get the proof to Shreya.
Yes, sir.
If you do one of those two things within the 2 weeks, this fugitive case gets dismissed.
Yes, sir.
I'm going to tell you now, Mr. Blackburn, you will never get another bond here for this case. Do you understand?
Yes, sir.
If you blow us off, I will issue a nationwide warrant for your arrest. I will set bond at 0, and we will hold you until Oklahoma comes and gets you. The only thing we're asking you to do is turn yourself in or post that bond and get proof to Shreya. You understand?
Yes, sir.
All right. So we'll set bond at 5,000, and then best of luck to you, sir.
Thank you,
Okay.
Judge. And I believe my waiver's up there. Did you? Waiver's top? Okay. Thank you.
Hi, Mr. D.
Yes, sir, your map for Judge, I'm here on Mrs. Janae Sias, S-I-A-S. My client was originally on bond for a theft case. She picked up another theft case and.
Yes, correct.
and,
She is not bonded out, right?
Yes, sir, she's bonded out.
Okay.
She's here.
Come up, ma'am. Hey, how are you?
Good to
Good
see
to see
you.
you. It's been a while. Where were we last together?
I was covering here as an intern during the ADA school, but now I'm back, now as a prosecutor.
How goes it? Good?
Yeah.
Great.
So I was helping Pablo
Yes,
out in
hey,
the court.
we welcome you. Thanks for helping. The next time you pick up another case, I'm gonna make your bond so high you're gonna flip. You are not allowed to go to any of these places. Do you understand? So one is Walmart, right?
Correct, Judge.
And the other one is Bath and Body Works or Marshalls, what was it?
Walmart, but I got you.
No,
Carter's, yeah.
Carter's, okay. So can you please file conditions, no going to Walmart or Carter's? No Walmart whatsoever for any reason. Do you understand? You go to Walmart, you go to Carter's, you pick up a new case.
It wasn't Walmart,
Yeah, it
Judge.
was a lot, yeah, it was.
Let's look at this thing. I didn't look at the new case. What was those two?
It's always one.
Yes, sir. No, one of them is court. Bath and body. Want to make sure.
The new one is a Bath and Body Works, and the old one is at Nordstrom Rack.
Nordstrom. nausea and that.
So do you mind filing those, please? So no going to Nordstrom Rack or any Carters? No new cases. Do I need to put an ankle monitor on you so we know where you are? You now have a lawyer. It's your responsibility to stay in touch with Mr. Dixon. If he tells me that he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Do you understand? Okay. Just please take a seat. Do not leave while we have you sign the bond conditions, man. Okay.
As we approach on Bueno, Sammy Bueno.
Page 30.
Used to be. Still
Judge, so I just got appointed. I was subbing out Trinidad for some reason. I don't know why, but I got appointed on both his cases. I was trying to reset it to Wednesday. My understanding is he picked up a new violation and I needed to approach because of that.
I'm okay with that. Yeah, if you just want to put it on for Wednesday. Huh?
You want to put them on?
That's what he's asking for. He's in custody. Yeah, you want to roll into Wednesday?
Yeah, sure. Here's what's going on. I just got appointed. There's something in there that makes me think there might be an issue with competency. So that's kind of why I wanted to look into it and just roll it Wednesday. And then Wednesday.
Want us to go ahead and issue the thing now? That way it's not, because it's a 30-day reset for comp, but you can get it started now and then come back on Wednesday?
I'm 50-50 on it. The only reason I want to investigate it is because where this incident happened is supposedly somewhere that might indicate something happened. So there's some. Okay.
One Wednesday.
Yeah, I'll just take Wednesday and hopefully we get it done Wednesday.
Okay. Yeah.
Great.
Sure. It's already on. It's 10,002 on the old one. They didn't give them a bond, so there's nothing to revoke. Yeah. Or raise, right? All right. How's jail? How's jail? You know, some people learn the hard way. Some people learn the easy way. Mr. Andrade, which one is you? You gonna finally get it? Well, we shall see. From now on, well, you know, everybody tells me that. You're never gonna see me again.
That'd be nice.
I hope not. So you're charged with 2 counts of driving while intoxicated. You've worked out an agreement where they're going to dismiss one, you're going to plead to the other one. This is a lifetime decision. This DWI is going to go on your record. And I'm telling you, if you ever get pulled over, an officer, they're going to see DWI, DWI. If they smell alcohol or dope on you, what do you think they're going to do? You will never, ever they're never going to let you go. They're going to harass the hell out of you, even with the faintest smell of alcohol. So I would never, even if you've had one beer, one shot, you try to take a chance, you're going to lose. That's the right way. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this, undo this. Do you understand? How do you plead to the offense, sir? I will find you guilty. So which one are we doing?
The older judge, the older one.
And what do we do? Is it 3 days in jail? I will give you credit for the 10 days that you've already done. I'm going to suspend your license for a year.
I come back and get my license, right?
Correct. Don't drive until that point, though, because I'm telling you, you're going to come right back to jail. All right. Good luck, guys. Oh, wait, did he say guilty or no?
Oh, yes, he did, Judge.
All right. Good luck. Let's go. Okay. What, say it again? What's the name?
Contreras Jonathan.
Contreras, that's right. On the 661. Okay, Mr. Contreras, you're charged with 2 cases. You're charged with interference with the duties of a public servant, which I think is the one that's getting dismissed. In exchange for your plea on the reckless driving, you're facing up to 30 days in jail and or a $500 fine. You've worked out an agreement where they're offering you 3 days with 2 days credit. This will go now on your record. You are now facing a minimum of 30 days in jail if you ever pick up another case. Do you understand?
Yes, sir.
Let me make one more thing abundantly clear to you. To those people who act like a schlemiel in a car, the Texas legislature has made it extremely easy for them to take your car and seize it from you permanently. If you are caught racing, reckless driving, donuts, this type of act or street takeovers, I'm telling you, because we had a guy here last week on his second case, they took and they seized his car. This is now your first reckless driving. You pick up another one of these cases, it's very well possible they take your car from you permanently. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty to something, you can never change this. You will be stuck with this for the rest of your life. How do you plead to this offense? I'm extremely serious that I couldn't believe it myself when they came in here and he told me that they seized his car. I couldn't believe it, but they're doing it. So be very careful. The next time you race, you may lose it permanently. Good luck, guys. Thanks. I'll roll you. I'll roll it. Don't worry.
Thank you.
Okay, Mr. Harris. Thanks, guys.
Make sure you go down to the suite. I'm here giving this, otherwise you'll have.
It's not on docket today.
Oh, I'm sorry, she's not on the document, Your Honor. It is.
What's the cost number?
2497994.
Two, 4, 9, 7,
994. Okay. So, ma'am, you're charged with harassment. You're facing up to 6 months in jail. Let me see. You're facing up to 6 months in jail and or $2,000 fine, but you're on felony probation.
We met with, had a hearing with the judge. The judge is not going to revoke her probation. She submitted to an assessment. They're just pending the results
Is
right now.
the 339th is who?
That's
Okay, Judge. There's only so many times that they're going to bend over backwards to help you in felony court. If you continue to pick up cases, at some point, they're going to revoke your probation and put you in prison. Do you understand, man? I mean, you have a lot of history. At what point are you going to get it? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you can no longer challenge this. Do you understand, man? This is what you want to do. How do you plead to the offense, man? How do you plead to the offense, man? I will find you guilty. You said it's 3 days in jail. I will give you credit for the 1 day that you've done. Good luck to you, man.
Thank you, Your Honor.
Thank you.
Your Honor, with the court fees, could you waive her court fees?
What do you do for a living, man?
I haven't worked since she put this ankle monitor on my bed.
Your Honor, she hasn't been working since she's picked up the case. She did retain me on the case, but I took it at really, really low fees because I handled another one of her cases. Right now, she hasn't been working at all. She was homeless for a while, but she just moved back in with her parents. And so she doesn't have any.
Oh, it's okay. I'll grant that.
Okay, thank you.
Good luck.
Thank you.
Thanks. Mr. Pena, coming up.
Mr. Pena's back.
How's jail? You don't get it though. You don't get it. Like some people they just don't get it. We gave you a chance. We've given you so many chances. You violated our bond at least 6 times on your first gun case. You pled 5 times you violated the first time. Picked up another case, a weed case, got rid of that case. Then you picked up another gun case. And when you picked up that third case, the gun case, you violated bond 7 times. That means I let you out at least 6 times and you violated conditions. And now you picked up a 4th case, and within 2 weeks of you getting out, you violate conditions, and you want me to let you out? Cute. What do you think I should say?
I later said, I didn't know it was in my parking lot. Like, I didn't know I couldn't go to my parking lot. Like, if not, I wouldn't have went outside at all. Like, that address, if you search it up, it's literally my parking lot. I didn't know I couldn't be in my parking lot. Like, I'm willing to do 24/7 house arrest, sir, to prove to you, like, I'm trying to do good for real. Like,
I don't believe you.
Like, I was really in my parking lot.
History is any indication. If I let you out in another 3 weeks, you'll be up here again with more violations. And Mr. Pena, you're way too much drama for me. I'm not going to do that again. I've learned my lesson. Fool me once, shame on you. Fool me 7, 8, 9, 10, 11, 12. Fool me 12 times, shame on me. I'm sorry, Connor. It ain't going to happen. Bye. If you think that this is the easy way out, you are 100% mistaken. I told you that I was going to make it a miserable experience, and that's what I'm going to do. You will be expected to continue with what you are doing now. And at the first instance you try to toy with me, I will issue a warrant for your arrest. I'm going to put you in jail. And now you will be stuck like Chuck, because I'm going to put you in a rehab facility in the jail. It's a minimum of 9 months, depending on how well you respond to treatment. And if you don't respond well, you're looking at about 1.5 years in custody. I'm going to do everything in my power to make sure that you're not going to kill yourself. More importantly, anyone else. And if that means keeping you with me, I'm going to do it in a heartbeat. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You didn't put sober court on this.
She doesn't create it, it's the VA.
Pavel, we didn't put sober court on
Yeah, I wrote the conditions.
Okay, I'm gonna just, can I write it in there?
I'll print it out whenever you sign it.
Okay, so what I want to do with you is Sober Court. Sober Court is a program that helps you get your life on track. And if you do well with them, they help you get a license for you to drive. But it's a program that's rewards you with things, right? You're now going to be doing a DWI education class. You'll be doing victim impact panels. You'll be doing community service. Depending on how well you do with them, they reward you. The rewards are that they will take away your community service and they will help you get a license. In fact, they will pay for you to get a license and a occupational, which is expensive. It's not cheap, but they will reward you with these things to help you pay for these things if you do well with them. That means attending, showing up, and not doing what you say you're going to do when in fact you're not doing it. You have to provide proof. Until we get you into Sober Court, though, you were with me. And if you try to play this game with me, I will put you in lockup until we get you into Sober Court. Do you understand? I'm not going to play this game with you. I want proof of what you're supposed to be doing. As part of this agreement, you will be doing a DWI repeat offender education class, 2 victim impact panels, a 4-hour anger management class, a TRAS, no alcohol, no drugs, guardian interlock, and random testing. You will also be doing the AA as well. Do you understand? Ms. Bielma, this is going to go on your record. It's going to be there forever. From now on, you are facing a minimum of 30 days in jail if you ever pick up another DWI. And actually, it's a second. So from now on, if you ever pick up another DWI, you will be facing a 3rd-degree felony, 2 to 10 in the penitentiary. Some people only learn by going to prison. Is that going to be you? I don't know. What matters is, what are you going to be thinking in 20 years? Not now. Time heals all wounds. In 5 years, you're going to forget about this. How do you plead to the offense, man? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. You know, I was telling Ms. Rodriguez here that the idea is to make your experience so miserable that you think twice. I don't know if we're here. Yeah, I don't know if we're there yet. Here with you. Only time will tell. You can shed as many tears as you want, but the real test is, what are you going to be doing when you're faced with the dilemma, when you're out there at a bar? Are you going to get in a car again, even if it's 15 years away? How do you plead to the offense, man? I will find you guilty. I will follow the agreement. So I still want her coming here with us, proving to us that she's doing AA, taking drug tests.
Casey, no.
3 times a week. And then the drug test will continue. Did you get a date for sober for the TRAS?
Yes, it's gonna be on the 19th.
Oh, 3 days? Oh, wonderful. Great. So this is great because that way we can get you in and expedite you as soon as possible. Okay, thank you so much. We're good. Yes, yes, of course. Oh, 2-year driver license suspension.
Oh, I just got it. Bubble form.
Hello? No, we already did. Thanks. Yes, ma'am. Yes. No, just that. Thank you. Mr. Olivares, what time does court start?
Sorry?
What time does court start?
8:30.
What time is it now?
I'm not sure, afternoon,
Look behind you.
12:05.
Why is it that you're 4 hours late?
I overstepped, honestly.
Next time I'm going to put you out. Do you understand me?
I understand.
You're charged with burglary of a motor vehicle. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On April 8th, 2024, officers were dispatched to 1516 Smallwood, Unit 1 in Harris County, Texas. DMV in progress. Complainant witnessed defendant breaking into her vehicle and did not give authorization to the defendant or anyone to be inside the vehicle. When complainant saw the defendant in the vehicle, she then turned on the lights through her key fob that was parked next to the vehicle, and the defendant was in. No reaction from the defendant while he was inside without permission. After that, both complainants approached the vehicle from the passenger side to question the defendant. Immediately, the defendant hopped out of the vehicle, ran off. Officers located the defendant who matched the description, and complainant filled out a witness admonishment form and identified the defendant.
Mr. Olivares, I'm going to find that there's probable cause to go forward with your case. I'm now sending you for a drug and alcohol test. I want to know what's in your system at all. And then I'm going to reset your case for tomorrow, and I want you back here tomorrow. Do you understand?
Yes.
If you come at this time tomorrow, things are not going to go well for you. In your seat at 8:30 tomorrow morning. Do you understand?
Yes, Your Honor.
Okay. So I'm going to have you sign a reset with Victoria, and then I'm going to get you with Jeremiah. We're going to send you for a drug and alcohol test now, and then I'll see you tomorrow morning.
That was it. That was our Fleischer for the day. He has been starting his streams extremely late lately. He's supposed to start at 9:30 my time, 8:30 his time, and I know that that's darn early. So yeah, okay, I'll give him a break. But I'm sitting there waiting and waiting and waiting, and it's hard because all these other court cases are going on that I could be getting. And I don't, because I have my dial stuck on him. The professional. We are all the professionals. Let me tell you. Let me tell you how professional we are. The mistakes that we made are probably on purpose so that other streams don't feel so bad about not being as professional. That's why we do it. My dad had me pick my own switch a couple times too, Ms. Claude. Yeah, we're all about not making any other channel feel bad. I think I started this stream on mute. Oh. Thank you. Thank you, YouTuber. And good day, Carolyn. Good day, mate. Listen, I made moderators because I can't watch chat and then do everything else. It's hard. I either I forget where I'm going, or sometimes I can't see chat because I'm doing these other things. My moderators help me so much. You don't even know what Fozzie did to my Discord channel. If you haven't seen my Discord channel, you should see my Discord channel because Fozzie fixed it up all nice. All right, guys. I'm going to go get ready for court. It's 7 o'clock here. Yeah, Vibers, have a great day. If anybody gets you down, just remember, every single person in this chat loves you, and we don't care. Thanks, Fozzie. Thank you. And Cha, go get into other courtrooms. You're gonna miss some. Thanks, Carolyn. Love you, Cloud. Did Cloud leave already? Oh no, right there. She's right. Wait, he's right there. They are right there. Cloud, you're gonna have to pick a name that makes it easier for me. No problem, Monica. Gambling and grumbling. Damn it, she did it again. Somebody tell her, knock it off. No pausing. Pause more. No laughing, laugh more. No short streams, longer streams. Guys, I will see you next time. I got a divorce from Judge Frost that I'm trying to get together. And and this lady, I'm just going to tell you now, this lady gets $3,500 a month in child support. And he doesn't have a job, or he has a different job that's part-time, and she gets $3,500 a month in child support. Man, I would have killed for 1,000. Anyway, and I got some, I think it's good. I haven't seen it yet. I got some Georgia courtroom clips I have to go through right now with a thick accent. Hopefully it's good. Hopefully it's good enough to get on here anyway. All right, guys. Have a good day and behave. It was so much fun.